Good morning. In our 2-minute tax talk today, I will consider transfer pricing and intercompany agreements and non-performance in light of COVID-19. Intercompany arrangements are governed by the terms of the underlying agreement. In circumstances where one of the parties does not perform, the question whether a defense for non-performance is available will depend on the terms of the agreement and the surrounding circumstances. In our earlier talk, we considered force majeure as a possible option, but there may also be other options, and now is a good time for companies to consider and review those underlying intercompany agreements. As a first option, consider whether the contract has been frustrated. The doctrine of frustration will apply where the intervening act renders performance of the agreement impossible or illegal. But such performance must genuinely be impossible or illegal, and in a cross-border scenario, it will be considered at the place where performance was due to be rendered. Strict principles will apply, and where the contract is frustrated, it will result in a discharge of the contract as a whole. A second option is to consider whether the contract can be severed and certain parts of it cut. The doctrine of severance will apply where the intervening act is less severe and where it affects only parts of the agreement. But strict principles apply to this doctrine, and in addition, the remainder of the agreement must also comply with the arm's length principle. And finally, consider whether the agreement can be amended by way of renegotiation. But in this context, look at the terms of the agreement and whether it can be amended or whether certain conditions are required to be met for such amendment, such as it has to be in writing. And crucially, the amended agreement must also comply with the arm's length principle. Failure to do that could have tax consequences.